Hi, I'm Emily Robinson. I'm a family law attorney and I practice with Dion Law Group in Westlake Village, California and in Encino, California. And I wanted to talk a little bit about what an emergency hearing is. So a lot of times people will come in and say, I have an emergency, we need to go to court right away. And very few things are considered an emergency to the court. Normally, you have to wait for your regular court date, which can be anywhere from 8 weeks out to 4 months out, depending on the court's calendar. The only way you can just walk into court with an emergency is if you have a true emergency. And what the court considers to be a true emergency are things like domestic violence, so safety, if somebody's life or health is in real danger. Somebody like your ex planning to take your children out of the state, because then it's very hard to get your children back. So that would be considered an emergency, is taking your children out of state. Obviously child abuse or something that would be very detrimental to your children, where they're experiencing like severe physical or dangerous consequences. And anything that would be an irreparable harm to a property, in the sense of my escrow is supposed to close tomorrow and my ex won't sign the papers, and if he doesn't sign the papers, I'm in breach of contract with the buyers and I'm going to lose the only community asset we have, something that significant. Otherwise, the court is really not going to consider it an emergency. One person's not paying child support. One person's not paying their spousal support. One person isn't paying the utility bills. One person's not paying the mortgage. None of those things are an emergency as far as the court's concerned. My child is struggling emotionally. My child is missing too much school. My child's getting a lot of tardies. Those are not emergencies. The reason is because the court has hundreds and thousands of people that have been waiting weeks or months for their own court dates. And you can't just cut that line unless you have a real, true emergency that if the court doesn't address tomorrow, something irreparable is going to happen. You can always file a regular motion for whatever issue you're having, and if it does become irreparable harm before your court date, you can try to advance that motion and have it heard sooner. But otherwise, that's what's considered an emergency, and the court does not want you to come in claiming something's an emergency if it's not. It just frustrates the court. It takes time away from the other people that have been set on the calendar for that day, and it could cause you to be sanctioned by the court at some point if you come in for too many reasons that aren't true emergencies. If you have any questions on this topic, you can contact me at 805-497-7474 or go to my video blog at westlakedivorceattorney.com.